Next, we have an arraignment and a motion in People v. Gloria Jean Dabbs. It's filed 25-7096 FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
No, now you're for Ms. Dabbs, who appears in person in custody to my right.
Good morning. And
before this courtroom session even finds its rhythm, we're thrown into a whirlwind morning docket where multiple lives hang in the balance, and the legal system moves at lightning speed. Today's lineup isn't just routine paperwork. It's a revealing cross-section of justice in action. We're about to see repeat drunk driving allegations, a defendant facing trial scheduling under custody pressure, a plea deal involving lying to police during a stolen vehicle investigation, probation violations tied to new criminal conduct, and a bond battle that could determine whether someone waits for sentencing behind bars or goes home to rebuild their life. What makes this session fascinating is how quickly judges must weigh risk, accountability, and public safety, often in minutes. One decision can mean freedom, another incarceration, and sometimes both outcomes hinge on a single admission or procedural choice. As you watch, pay attention to how each defendant's past behavior, current charges, and courtroom strategy shape what happens next, because in this courtroom, history matters just as much as the present allegation.
For arraignment purposes, if you and Ms. Dabbs had opportunity to review the felony information.
We have, Your Honor. She would waive the reading at this time of both her rights and the formal charges. We would enter a not guilty plea at this time.
All right, we'll enter a plea of not guilty on the charge of operating while intoxicated, third offense. And is a forensic center referral requested?
No, Your Honor.
All right, estimated length of trial?
I would say probably 1 day.
You have a motion with regard to bonds. You want to go ahead and argue that?
We did, Your Honor. What I would like to do at this time, Ms. Dabbs is requesting that we postpone having that bond review hearing for a couple weeks. If the court has any availability late January, that would be a request at this point.
Well, I have a date 1 week from today, January 13th, and then I also have February 3rd.
I'm in a jury on the 13th, so that's not good for me. The 3rd.
Okay. Let's go ahead and set this then for a docket call on February 3rd at 10:10 a.m. And we'll have bond motion the same date and time.
Thank you, Your Honor. Ms. Dabbs does also want to request to be put on the trial calendar. If we could go ahead and get her a date set for that as well.
Yes. Okay. Information. Well, it depends on how fast you want to get it there. I have a 1-day trial slot on February 19th.
I can just check the calendar. Looks like it works for me. If it works for the people.
Does that sound fine? Okay. So we'll set it for jury trial February 19th. We'll exchange witness and exhibit lists. Can we do that within 14 days then?
Yes.
That should be fine.
All right, anything else from the defense?
No, Your Honor, thank you.
Anything else from the people?
No, Your Honor, thank you.
Okay, you're all set, Ms. Dabbs. We'll see you for a docket call on February 3rd. And we'll continue the bond motion till then. That'll be a plea cutoff date as well. And we've got your jury trial scheduled for February 19th.
Thank you, Judge.
Thank you.
What we just saw is a textbook arraignment on a serious repeat offense charge, operating while intoxicated, third offense. In most jurisdictions, that's no longer treated like a standard DUI. It's a felony-level allegation reflecting a pattern of dangerous conduct. Notice how the defense immediately waived the formal reading and pushed scheduling forward. That's a strategic move. Get to trial quickly, preserve rights, and potentially challenge evidence before negotiations begin. But the real subplot here is the delayed bond motion. By postponing the bond review, the defense buys time, possibly to gather mitigation evidence like treatment enrollment, employment verification, or sobriety monitoring plans. Judges often weigh those heavily when deciding release. So here's the key question for you. When someone has multiple intoxicated driving allegations, should the focus be punishment or rehabilitation? And at what point does public safety outweigh second chances?
All right, and next we've got people v. Caitlin Enick by 25-7110FH.
No, not yet. Ms. Enick, who appears in person in custody, shortly to my right.
And Ms. Enick, all right, for arraignment purposes, Mr. Nightingale, do you or your client want to have the allegations read?
No, Your Honor, we would waive formal reading of charges and rights at this time. We have tendered a plea for the court's consideration this morning.
Okay, and is the forensic center referral requested?
No, Your Honor.
Ms. Enick, could you please stand and as best you can raise your right hand for me? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can be seated. All right, Ms. Enick, a guilty plea hearing is an important event because you have a lot of rights under our Constitution and laws that you waive by entering a plea. So I want you to listen carefully. If you have any questions, you can ask me. I'm happy to answer them. If you need a minute with Mr. Nightingale, just let me know. Looks like you're offering to plead guilty to count 3. Count 3 is a charge of lying to a peace officer in an investigation involving a penalty of 4 or more years. That crime is a high court misdemeanor, punishable by up to 2 years in prison and or a $5,000 fine. Do you understand that maximum penalty?
Yeah.
Were you on bond for any other case at the time of this incident?
No.
Were you on probation or parole?
Yeah.
Okay, you're on probation out of district court at the time?
Yeah.
Okay, and are you aware then if you enter a plea in this case, that could also be used against you in your probation downstairs?
Yeah.
Did you read and understand the rights listed on the advice of rights form?
Yes.
And you signed that, looks like last month? Do you have any questions for me or Mr. Nightingale about any of those rights?
No.
Do you understand if you plead guilty, you give up all those rights and won't have a trial?
Yes.
And is that what you want to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by any threats or by any promises not put on the record today. Do you understand that?
Yes.
Also, when you plead guilty, you give up the right to an appeal. And if you wanted to appeal, you'd have to seek permission to do so by filing an application. But the types of issues that you could raise on an appeal after you plead guilty are very limited. Do you understand that?
Yeah.
The plea agreement provides an exchange for your plea of lying to a peace officer. The other charges and the habitual enhancement will be dismissed. And there's a sentence agreement for a county cap, meaning the most that I could sentence you to at the initial sentencing would be a year in the county jail. Do you understand that?
Yes.
This moment is where the legal stakes crystallize. The defendant isn't pleading to the most serious alleged conduct. Instead, the agreement narrows everything down to lying to a peace officer during a vehicle theft investigation. That's significant because plea negotiations often reshape cases dramatically. Here, multiple charges and a habitual enhancement disappear in exchange for a single conviction capped at 1 year in county jail. But there's a hidden danger the judge carefully explains. She was already on probation. A guilty plea doesn't just resolve this case. It can trigger consequences in another court entirely. That's why judges emphasize voluntariness and understanding so intensely during plea colloquies. They're creating a record showing the defendant knowingly accepted those risks. So think about this. If admitting guilt in one case can worsen another sentence elsewhere, is the plea still a fair trade or a pressured decision driven by immediate relief?
Mr. Nightingale, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. Juliet?
Yes, miss.
Ms. Enick, that sentence agreement for the county cap is not binding on me, meaning I don't have to follow it. But if I did not follow it, you'd be allowed to withdraw your plea because you wouldn't be getting what you bargained for. Do you understand that?
Yes.
There is a very important exception to that rule. If you engage in any misconduct between now and your sentencing date, say by violating court orders or absconding or escaping or committing new crimes, then I wouldn't have to follow that sentence agreement, but you would have lost the right to withdraw the plea by your own misconduct. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all that, how do you wish to plead to the charge in count 3 of lying to a peace officer?
Guilty.
Mr. Nightingale, would you assist with the factual basis for that?
Of course, Your Honor. Thank you. Ms. Enick, on or about October 19th of 2025, you were in Sheboygan County, state of Michigan, right?
Yes.
And on or about that date and time and place, you had some police contact, did you not?
Yes, I did.
And the police, specifically officers alive with the Mackinac City Police Department, interviewed you, correct?
Yes.
And you knew that he was an officer investigating some sort of crime, is that correct?
Correct.
And that crime that he was investigating, you knew was an unlawful driving away of a motor vehicle, is that right?
Yes.
And when he was interviewing you, did you knowingly and willfully make a statement or statements to that officer that you knew were false or misleading regarding that investigation?
Yes.
And it was about material facts in that investigation. Is that fair to say?
Yeah.
I think that satisfies the factual judge. I have no further
Okay,
questions.
Mr. Juliet, you agree?
I do.
Mr. Nightingale, you aware of any other promises to term inducements?
No.
You believe I've complied with MCR 6.302?
Of course.
Mr. Juliet, do you agree?
I do.
All right, Ms. Senek, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is sufficient basis in fact and in law for me to believe you're guilty of that crime. So hereby accept your plea. We'll schedule sentencing for February 10th at 10:10 in the morning. You'll have to cooperate with probation agent interviewing you to write a pre-sentence report, so they make recommendations to me about what a proper sentence would be. Anything further from the people?
Thank you.
From the defense?
Just briefly, Your Honor, Ms. Enick does at this point want to try to address bond. I know that the court may deny that request at this point, considering that she's now just pled guilty. She is aware also that she's got a no bond hold out of district court, so we have to address it there as well before she could even get out. But she does advise that she's got a good job to go back to, that her mom wants her out of custody, obviously. She's got a dog that she needs to take care of and needs to start paying down some of these court fines out of district court as well. So that's what she's asking for today, is to lower her bond to something that's postable. I don't necessarily want the court to just straight up PR for, since she does have that district court hold, but if there's something that we can get down to that she could get back to work while we're processing her sentencing, that would be the request of this. Thank you.
Mr. Juliet, your response?
I guess there's a good argument to simply revoke bond right now. I mean, she was on probation for 2 one-year misdemeanors at the time of the offense. She got several felonies dismissed. I think bond's appropriately set where it's at. I mean, it's pretty immaterial, and it's just no bond in district court.
Looks like just in August, she was convicted in district court of a couple of attempt RNOs, and then there's this incident which she wasn't the driver, right?
That is correct. She was
Okay, she wasn't the driver, but she was participating in an incident that had a pretty significant public safety risk component to it. And now, having entered the plea, I'll leave bond as set. We'll see you on February 10th.
Thank you, Judge.
The judge's bond decision here reveals how courts balance compassion against community risk. The defense painted a sympathetic picture: employment waiting, family support, even responsibility for a pet. Classic arguments to show stability and likelihood of returning to court. But the prosecution reframed the narrative around pattern and timing. The defendant was already on probation and still became involved in a high-risk criminal incident. That's often decisive. Judges look less at promises and more at demonstrated behavior. Past compliance predicts future compliance. And here, recent convictions plus probation status undercut the release request. Also crucial, even if this court reduced bond, another court's hold would still prevent release. So the judge essentially preserves status quo while avoiding inconsistent rulings across jurisdictions. Here's the broader debate. Should bond decisions focus on current charge severity or overall criminal history? Because depending on that philosophy, outcomes can look very different.
All right. And next we've got People v. Devin McLeod. This is arraignment in 25-7108FH and a probation violation hearing in 22-6316FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
No, and I go here for Mr. McLeod, who appears in person in custody to my right.
Right, and in the new file, the 25 file, for arraignment purposes, have you reviewed the charging document with Mr. McLeod?
Have Your Honor, he would waive a formal reading of both the charges and is right to this point. No forensic center requested, probably a one-day trial.
Okay. All right, so we'll enter a plea of not guilty to failing to comply with recording duties, habitual third. So as counsel looked at on both sides, I guess, my head spins every time I get a SORA case now. Whether this case and these facts are implicated by any of the ongoing litigation or issues or not, or do you had a chance to look at that, Mr. Nightingale?
No, not particularly, Judge.
Okay. All right. Well, let's set this then for a docket call. February 3rd at 10:20. I guess given the legal landscape, I won't place this on our expedited docket just in case there's any sort of motions that are necessary for that. I have no idea. And in the probation matter, do you want that to be continued to the same date and time to track with it?
Yes, Your Honor, please.
Okay, so we'll continue then the probation violation hearing to the same date and time, February 3rd at 10:20 a.m. Anything further from the defense,
No, thank you, Judge.
from the people?
No, Your Honor, thank you.
Okay, we'll see you then.
Thank you, Your Honor.
And this would bring us to docket calls in People v. Jennifer Bird. Two file numbers 25-7083 and 7085. Counsel, you want to state your occurrences, please?
No, not guilty for Ms. Miller, who appears in person to my right.
All right, we're here for a docket call in both of these files. What's our status, Mr. Gauthier?
Thank you, Your Honor. So I think we're still actively negotiating on both these files. I think as the court's aware, these can be a little complicated. Not the most complicated cases, certainly, but there's a lot of moving parts here on both her cases. And so we're going to request a little bit more time to get through these plea negotiations and hopefully resolve both these cases without trial. If we could have that either the February 3rd or the February 10th date.
Okay. Mr. Joliet, you have a preference between the 3rd or the 10th?
I think that we're
All right, we'll schedule both these files then for a docket call on February 3rd at 10:30 a.m. Anything further from the people?
no, thank you.
From the defense?
No, Your Honor, thank you.
Okay, we'll see you then, Ms. Bird.
Thank you.
Let's go off the record for a second. Court, and we have a probation matter in People v. Tricia Brigandi, file 24-6785FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
No, and I have Ms. Brigandi, who appears in person to my right.
All right, good morning. And this was a probation violation hearing regarding violation of probation for having an animal, a dangerous animal charge. And counsel has informed me that that matter has been resolved in the district court. Is that correct, Mr. Nightingale?
That is correct, Your Honor. Ms. Brigandi did plead and was sentenced on that case last month.
All right, and so Ms. Brigandi, you understand you have the right to have a probation violation hearing in this matter?
Pardon?
You understand you have the right to have a probation violation
yes,
hearing in this
yes,
case?
sir.
Do you wish to waive that hearing and just enter and admit that you violated your probation?
Yes, sir.
Okay, so you are on probation of this court,
Yes.
and part of that probation is to not violate the laws of the state of Michigan, is that right?
Correct.
And did you plead guilty to a violation of state law involving your animal in the district court?
Yes, I did, sir.
Okay. Has anybody promised you anything in exchange for that admission here?
No, sir.
Has anybody threatened you?
No, sir.
Is it your own free choice?
Yes, sir.
All right. Well, I find that your admission to the probation violation is knowingly, understandingly, and voluntarily made, and that does constitute a violation of probation. And I know Ms. Brigandi is a participant in our recovery court program and is making good progress there. Ms. Goodrich, do you have any sanction that you'd request?
Your Honor, we're not looking for any additional sanctions other than what the district court ordered. Ms. Brigandi was cooperative in that case and appropriate at sentencing and giving her statements to the court at that time.
Okay, Mr. Nightingale, any input?
Just briefly, Judge, I think Ms. Brigandi obviously still feels terrible about this whole incident. I think as the court heard off the record that she did do the right thing here and, unfortunately had to euthanize this dog without court intervention. She's accepted responsibility for this. She just feels terrible. And obviously we're very thankful that the people aren't moving forward with any sort of sanctions, and we hope the court accepts the same. Thank you.
Okay, thank you. Ms. Brigandy, you don't have to say anything, but you're welcome to. Is there anything you want to tell me today about that or no? That's fine. That's fine. I know these cases are hard for all the folks involved, you know, so I understand that. All right, well, I'm glad that it was brought to a resolution in the district court. And I think given Ms. Brigandy's progress in our recovery court program, we'll track this as a violation. I'll enter the order making that finding, but I'll just continue her probation without further sanction or amendment of its terms.
Thank
you.
Thank you.
You're all set. So you're all set, Ms. Brigandy.
Thank you.
Let's go off. All right, and up next, we have People v. Stephanie Becker. It's filed 25-7067 and 7068. Discussed with counsel some scheduling issues Ms. Becker had in another court, as well as some ongoing health issues that she's navigating. And we're going to continue the sentencing and the show cause in both files then to February 3rd at 10:40 a.m. Any objection to that, Ms. Goodrich?
No objection.
Mr. Nightingale?
No, thank you.
Okay, and we'll excuse her appearance today.
Thank you, Judge.
Let's go back off the record. All right, we're back on the record, and essentially our last case on the morning docket, People v. Ashton Moxlow, filed 23-6743 FC. Counsel, you want to state your appearances, please?
Melissa Goodrich, Plain County Prosecutor.
Liz Elliott on behalf of Ashton Moxlow, who sits to my right.
All right, we're here for a probation violation hearing in this matter. The allegations stem from a Benzie County criminal case that is pending. So, Ms. Elliott, how does your client wish to proceed?
Well, Your Honor, it's my understanding that he will be arraigned out of Benzie County on the 8th of January. So we would just ask to adjourn this out to allow that process to kind of move forward.
Okay, I can give you February 10th at 10:20 a.m.
That works.
Any objection to that, Ms. Goodrich?
No objection.
Okay, we'll continue it until that time. Anything further from the defense?
No, Your Honor, thank
From the
you.
people?
No, Your Honor.
Okay, we'll see you then, Mr. Maxwell. Should be adjourned until 1 p.m.
I'll be
Good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. First up, we're going to conduct an arraignment in a bench trial or a bench warrant in People versus Tristan Long, file 25-6997 FH. Counsel, you want to state your appearances, please?
Anthony Juliet on behalf of People.
Liz Elliott on behalf of Tristan Long, who sits to my right.
All right, good afternoon. And we did call Mr. Long's case yesterday, but we had also a motion by his previously retained attorney to withdraw. It was granted. And so then I thought, well, we should postpone the arraignment until he had a chance to consult with counsel. Mr. Long, it is alleged that you are in contempt of court for failing to appear in this court back on October 7th of this year for a docket call in your underlying felony case. You have the right to have a hearing at which that contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of a lawyer. If you qualify and request, you would be qualified for an attorney at public expense. You can present evidence in your own defense, and you can cross-examine any of the evidence presented against you. Do you understand those rights?
Yes, sir.
If you're found in contempt, I could jail you for up to 93 days, or I could fine you for up to $7,500 or both. Also, if I believe that you're not complying with the conditions of your release, I can revoke that release. Do you understand those penalties?
Yes, Your Honor.
Ms. Elliott, do you know how he wishes to proceed?
Not guilty.
All right, so we'll set this for a contempt hearing, and I think we also need to schedule it then for a docket call on the underlying charge of felony false pretenses with the habitual notice. And Ms. Elliott, has Mr. Long requested assigned counsel?
He has not, Your Honor. I believe he's going to retain counsel.
Okay, you're going to retain your own attorney then?
Yes, Your Honor.
Okay. What I'll do then is I can schedule this for docket call and contempt hearing on February 3rd at, we'll just put it right at 1 p.m. As to any release request for Mr. Juliet?
I would ask that bond be denied at this point. Due to his failure to appear in absconding felony was issued, that's pending in district court. I would ask that bond be denied.
Ms. Elliott?
We don't have anything, Your Honor.
Okay. Yeah, Mr. Long, I guess I'll continue at this point to revoke your release and hold you without release until further order of the court till we sort out what's going on. I'll see you next on February 3rd at 1 p.m. It's up to you to get that attorney retained and ready to, so that he's ready to go on that date and time. Otherwise, the time you just sit waiting for the case to resolve will linger, right?
Yes, sir.
Okay. All right, we'll see you then. All right, and then next we, on our civil docket, we have a bench trial in Holderman et al. V. Bruckman et al. File 24-9044CH.
This morning docket illustrates the layered reality of criminal courtrooms. Quick procedural appearances masking complex life consequences. We saw a felony repeat intoxication charge pushed toward trial, a negotiated guilty plea that traded multiple allegations for a capped sentence, a bond request denied due to probation status and public safety concerns, and multiple probation matters where new conduct reshaped existing supervision. What stands out most is how interconnected cases become once someone is already under court supervision. A single new offense can ripple across jurisdictions, affect release status, and limit sentencing options. Judges must constantly weigh fairness to the individual against risk to the community, often with incomplete information and tight timelines. And that's the reality behind courtroom headlines. Decisions that seem routine are often the culmination of history, behavior patterns, and negotiated compromise. If you found this case as revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.